considering the pleadings of the petitioners and the added evidence profiled by them, whether the petitioners have not woefully failed to prove any of the allegations of non-compliance with the provisions of the Electoral Act 2010 as amended, corrupt practices, and that the second respondent was not duly elected by majority of lawful votes cast at the presidential election of the 23rd of February 2019. And lastly, 3, considering the feeble case presented by the petitioners before this honorable court, whether the court can decree that the first petitioner was duly and validly elected as President of the Federal Republic of Nigeria at the presidential election held on the 23rd of February 2019. On his part, the learned senior counsel for the third respondent also identified 6 issues in his final address, which he says require determination in this petition. And I quote him too. 1, whether in the circumstances of this petition, the petition is competent, and whether the paragraphs which the third respondent is objecting to are regular and valid. 2, whether the second respondent was at the time of the election not qualified to contest the said election. 3, whether the second respondent submitted to the first respondent an affidavit containing false information of a fundamental nature in aid of his qualification for the election. 4, whether the petitioners have proved the allegation of corrupt practice in the conduct of the election, the office of the President of the Federal Republic of Nigeria beyond reasonable doubt. 5, whether or not the presidential election held on the 23rd of February 2019 was conducted by the first respondent in substantial compliance with the provisions of the Electoral Act 2010 as amended, the guidelines and manual for election officials 2019. And lastly, whether the second respondent was duly returned with a majority of lawful votes cast at the election into the office of the President of the Federal Republic of Nigeria held on the 23rd of February 2019. Dr. Levi Uzoku-Ezean, lead counsel for the petitioners, in the final address, raised 5 issues for determination in this petition. And they are as follows. 1, whether the second respondent was at the time of the election not qualified to contest the election. 2, whether the second respondent submitted to the first respondent affidavit containing false information of a fundamental nature in aid of his qualification for the said election. 3, whether from the pleading and evidence led, it was established that the second respondent was duly elected by majority of lawful votes cast at the election. 4, whether the presidential election conducted by the first respondent on the 23rd of February 2019 was invalid by reason of corrupt practices. And lastly, 5, whether the presidential election conducted by the first respondent on the 23rd of February 2019 was invalid by reason of non-compliance with the Electoral Act 2010 as amended, the Electoral Guidelines 2019, and the manual issued for the conduct of elections, end of quote. The same issues were raised in the petitioner's final written address in reply to the final address of each of the respondents to the petition. I am of the view that the issues formulated by Dr. Levi Uzoku-Ezean for the petitioners represent the complaints and the grounds upon which this petition is brought and can be utilized for the determination of the petition, and the said issues will be considered in sequence and order they were argued by the learned senior counsel for the petitioners, as well as the other counsel for the respondents. I went ahead to do so. There are several arguments canvassed in respect of issues 1 and 2 by all the learned senior counsel for the parties. I'll go to the resolution of the issues 1 and 2, canvassed by the parties. The petitioners have pleaded in paragraph 388 to 405 of their petition that the second respondent does not possess the requisite educational qualification to contest the presidential election conducted on the 23rd of February 2019, and that he had submitted to the first respondent an affidavit containing false information of a fundamental nature to aid in aid of his qualification for the said election. In view of the enormity of the time and energy devoted to the allegations of the parties in this petition and the submissions by the learned senior counsel, the broad spectrum provisions of the Constitution, the Electoral Act 2010 as amended, it is in the interest of justice to reel out the entire pleadings of the petitioners relating to issues 1 and 2 under consideration. And I did. I set them out. Now, have resort to the Constitution and the Electoral Act as amended on non-qualification and disqualification of the second respondent to contest the February 2019 election. The reason is that it is said that the Constitution and the Electoral Act, the reason is that it is the said Constitution and the Electoral Act that govern matters or issues relating to qualification and grounds for presentation of an election petition, on the ground that a candidate is not qualified to contest a particular election. The court will be guided in the interpretation of the provisions relating to the qualification in the said Constitution and the Act by decided cases. The Supreme Court has settled that when it comes to qualification to contest an election, recourse must be had to the provisions of the Constitution of Nigeria and the Electoral Act as amended. In the case of Ucha and Onwe, decided in 2011, citation of which is set out, Tabai JSC stated, and I quote him, "It was, in addition to the petitioner's first respondent, also relied on Emero and Duru, 2004-9 Nigeria Law Report, Part 877, page 75, OB, 2005-6 NWLR, Part 920, at page 1 to 3. In Emero and Duru, the case of the first respondent was that he was duly nominated by his party, screened and cleared, and indeed contested the election of 16th April 2003, and won and was duly issued with from EC8E1 by the returning officer. Thereafter, the second to third respondent purported to cancel, withdraw, and invalidate the said Form EC 8E1 and declared the appellant winner of the said election. The first respondent therefore filed a petition at the Election Tribunal which gave him judgment and granted the relief as follows. The appeal to the Court of Appeal was dismissed. In the concluding paragraph at page 106 of the report, JCA, as it then was, concluded. In conclusion, this appeal is devoid of merit. The appellant who did not contest an election cannot be returned. He has no seat in the House of Representatives. It is clear from the report that the petitioner actually contested the election and won. He was issued a certificate of return, and the substitution on the petition was predicated, and the substitution on which the petition was predicated was made after the election. The matter, therefore, was clearly a post-election matter over which the Election Tribunal had jurisdiction. In the circumstance, I hold that the authority does not support the principle postulated by the counsel for the first respondent. I have also read a banner and OB cited by the learned counsel. I cannot say without any equivocation that the case has no bearing whatsoever upon the issue of proper venue for a pre-election or post-election dispute. The learned counsel for the first respondent made further reference to provisions of Section 246(1)(b)(1) of the Constitution on appeal to the Court of Appeal. His Lordship went on. And concluded that the result of both analysis is that the appeal has merit and should be and is hereby allowed. The nomination and substitution of the first respondent upon which the petition was predicated was clearly a pre-election matter over which only the Federal High Court or State High Court has jurisdiction. Then in INEC, in PDP and INEC, 2014, as I mentioned, Okoro JSC said, as I mentioned earlier, a person who wishes to challenge the election on the basis that the winner was not qualified to contest the election has an umbrage under Section 138(1)(a) of the Electoral Act. That is to say, where a person failed to take advantage of Section 31(5)(6) in the High Court, he can still approach the Election Tribunal under Section 138(1)(b). Now, Section 177 of the Constitution of the Federal Republic of Nigeria. Well, that is not should continue. Sections 131 and 137 of the Constitution of the Federal Republic of Nigeria, which are relevant in this petition as amended, are as follows. And I set them out. A person shall be qualified for election to the office of president if A, is a citizen of Nigeria by birth, B, he has attained the age of 40 years, C, he is a member of a political party and is sponsored by that political party, and D, he has been educated up to at least school certificate level or its equivalent. Section 137(1). A person shall not be qualified for election to the office of president if, subject to the provisions of Section 28 of this Constitution, he has voluntarily acquired citizenship of another country other than Nigeria, or except in such cases as may be prescribed by the National Assembly, he has made a declaration of allegiance to such other country, or B, he has been elected to office at any other two previous elections, or C, under the law in any part of Nigeria, he is adjudged to be a lunatic or otherwise declared to be of unsound mind, or D, if he is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or a sentence of imprisonment or fine for any offense involving dishonesty or fraud by whatever name called, or for any other offense imposed on him by any court or tribunal, or substituted by a competent authority for any other sentence imposed on him by such a court or tribunal. E, within the period of less than 10 years before the date of the election to the office of president, he has been convicted and sentenced for an offense involving dishonesty, or he has been found guilty of the contravention of the Code of Conduct, or F, is an adjudged bankrupt, having been adjudged or otherwise declared bankrupt under any law in force in Nigeria or any other country. Or G, being a person employed in the civil service or public service of the Federation or any state, he has not resigned, withdrawn, or retired from employment at least 30 days before the date of the election. Or H, he is a member of any secret society. Or J, he has presented a false certificate to the Independent National Electoral Commission. Subsection 2, where in respect of any person who has been adjudged a lunatic, declared of unsound mind, sentenced to death or imprisonment, or adjudged a declared bankrupt, any appeal against the decision is pending in any court of law in accordance with any law in force in Nigeria. Subsection 1 of this section shall not apply during the period beginning from the date when such appeal is lodged and ending on the last day when the appeal is finally determined, or, as the case may be, the appeal lapses or is abandoned, whichever is earlier. Subparagraph 3 of Section 137(1) of the Constitution says, a person who was sworn in as president to complete the term for which another person was elected as president shall not be elected to such office for more than a single term. End of quote. Now, Section 318(1) of the Constitution defines what the term school certificate or its equivalent mean as provided under Section 31. It provides thus: school certificate or equivalent and guild certificate, or B, education up to secondary school certificate level, or C, primary school leaving certificate or its equivalent. Or that should be Roman 1. Service in the public service, in the public or private sector, in the Federation, in any capacity, acceptable to Independent National Electoral Commission for a minimum of 10 years. And 2, attendance at courses and training in such institutions as may be acceptable to the Independent National Electoral Commission for periods totaling up to a minimum of 1 year. And 3, the ability to read, write, understand, and communicate in English language to the satisfaction of the Independent National Electoral Commission. And D, any other qualification acceptable by the Independent National Electoral Commission. End of quote. The petitioners have argued strenuously that failure by the second respondent to attach the certificate listed in Form CF001 to this form means that the second respondent does not possess the certificate he claimed in Part C of the said form about the schools attended or the educational qualification with dates, and that evidence of all educational qualification should be attached. The second respondent stated in the said column that he attended primary school and has primary school certificate in 1952, that he has secondary education and was in 1961 for his higher school. He stated officer cadet 1963. There is no evidence before this court to show or prove that the second respondent lied that he went to the primary school, secondary school, or that he joined the army in 1962 with RW1 and many other persons in the second respondent's CV attached to Exhibit 1, which was the form FCF001 attached to the second respondent name, which was submitted to the first respondent. The Exhibit P1 tendered by the petitioners at page 1 thereof shows conclusively that the second respondent attended primary school and that he attended Katsina Provincial School, now Government College in Katsina, between 1956 to 1961, and went to Nigerian military training from 1963. The evidence of RW1 and RW2 also bear testimony to the aforesaid fact. The said LW1 and LW2 established beyond doubt that the second respondent had educational qualification which had stated his educational qualification in Form FC 001 on the 18th of October 2018. The Learned Senior Counsel for the petitioners had argued that the evidence led to prove the second respondent attended primary school, or that he attended some courses is irrelevant because he did not rely on any of those qualifications in XBP1. With respect to him, the argument is faulty because the Form CFO 001, which is admitted as XBP1, specifically asked the second respondent the school he attended with qualification attained or obtained in order to determine whether the second respondent has attended or have been educated up to at least school certificate level or its equivalent, which is part of the qualifications stipulated in Section 131 of the Constitution of the Federal Republic of Nigeria. The petitioners have also relied on Sections 76 and 31 of the Electoral Act 2010 as amended, and that it is compulsory for the second respondent to attach evidence of qualification to Exhibit 1. Section 31(4) of the Electoral Act provides, and I quote, "Any person may apply to the Commission for a copy of nomination form, affidavit, and any other document submitted by a candidate at an election, and the Commission shall, upon payment of a fee prescribed, issue such a person with a certified copy of the document within 14 days. The above section of the Electoral Act does not say in any way that a document or school certificate or certificate of qualification be attached to the said form. In any event, Section 31(4) of the Electoral Act must be read together with Section 31(2) of the same Act, which says, I quote, "The list or information submitted by each candidate shall be accompanied by an affidavit sworn to by the candidate at the Federal High Court or High Court of the State or Federal Capital Territory, indicating that he has fulfilled all the constitutional requirements for the election to that office. The reasonable inference and plausible meaning attachable to the above provision of the Electoral Act as amended is that a candidate can list information concerning evidence of his qualification or other relevant information about him. The demand or information required in Exhibit 1 cannot be more or higher than the statutory requirement. Section 76 of the Electoral Act, as amended, provides the forms to be used for the conduct of election under this Act shall be determined by the Commission. Where the provisions of a statute is straightforward and unambiguous, the court cannot read anything into the statute what it does not contain. The statute must be succinctly read, must be solely interpreted in a manner that will project and bring out succinctly the real intention of the lawmakers. No extraneous matter should be allowed to stray into the principle of interpretation of an act or the Constitution. The cases referred to, in my view, the provisions of Section 76 of the Electoral Act is clearly inapplicable to the issues under consideration. The form referred to in the said section are the form to be used in the conduct of an election as the Form Exhibit A has been taken care of in Section 31 of the Electoral Act, and the said exhibit is tied to the steps laid down in the said Section 31 of the Electoral Act. More importantly, the law is firmly settled that a candidate is not required by the Constitution or the Act to attach his certificate to Form C01 before the candidate can be considered or adjudged to have the requisite educational qualification to contest the election. For instance, in the case of Kaki and PDP, decided in 2014, citation of which is set out, Galadima JSC has stated that the contention of the appellant that the fourth respondent was not qualified to contest the election because of non-presentation of his certificate. However, the court below recognized the fact that as earlier observed, the appellant has contended that having regard to Sections 182(7)J of the Constitution, the fourth respondent is necessarily required to present his certificate to the first and second respondent in order to prove his qualification to contest the election. Otherwise, he is disqualified under Section 177D of the Constitution, and that by Section 167D of the Evidence Act, the failure is fatal because if produced, it would have been unfavorable to him. This contention is misconceived. Submission or presentation of a certificate is not the requirement of Section 177D of the Constitution as regards the gubernatorial screening process. The process of screening the appellant and the fourth respondent undertook with the first respondent requires that the candidates to fill in his qualification in the form and to swear to a verifying affidavit that the information contained in Form CF-001 was true. This takes away the necessity of presentation of actual certificate to the first and second respondent. When the appellant was confronted under cross-examination with Exhibits C and D, the nomination form, which is similar in form with INEC Form CF-001, and with the first respondent used in screening the appellant and the fourth respondent, he stated that he did not attach his certificate to his party nomination, form, and that he did attach his certificate to his primary nomination form, party nomination form, and that the same procedure of not attaching certificates to the nomination form applied to all candidates. He admitted that presenting or submission of certificate was not a requirement for the purpose of screening. See page 1711, volume 1 of the record. In any case, his lordship continues, it is not a requirement of Section 177D of the Constitution for the candidate to necessarily present the certificate to qualify for election to the office of governor of the state. By the provisions of Section 177D of the Constitution, a person shall be qualified for election to the office of governor of the state if D, he has been educated up to at least school certificate level or its equivalent. By Section 138(1), school certificate or its equivalent means B, educated up to secondary school certificate level. In Bio and in JIDA, 2004, at NWNR, Part 876, 544 at 630, 2004 FWLR, Part 192, page 10 at 78, the Court of Appeal, then the apex and final court on election petition, Assembly/Governorship and Legislative Houses Election Tribunal, had this to say on the point, and his lordship courts the presentation or the holding by the Court of Appeal. In other words, as regards a secondary school certificate examination, it is enough, in my view, that one attended school certificate level, that is, without passing and obtaining the certificate, end of quote. His lordship continued, by the combined reading of Section 177D and Section 138B of the Constitution, it is not only the requirement or basis, which is not the only requirement basis for qualification, but the candidate has been educated up to secondary school level. I am on an agreement with the Learned Council for the respondent that it is not only by presentation of certificate of the respondent that is the only proof that the fourth respondent is qualified as the appellant here, who has taken his disposition and did not by his own showing under cross-examination present or submit one. As rightly held by the court below, by Section 131 to 134 of the Evidence Act, it is only by cold facts presented to the law court that the civil rights and obligations of the parties are determined. By dint of these foregoing sections of the Evidence Act, Learned Council would do well for the litigants, who would be happier if they shown sentiments, as this command no place in judicial deliberations. See Ogbiti and NAOC Limited, 2010-14 NWLR, Part 1213, page 208. A litigant must be able to establish his case on the evidence he presented before the court or on known and settled principles of law. In sum, the appellant, having failed to show that the concurrent findings of fact by the lower court is perverse, thereby occasioning miscarriage of justice, I cannot disturb the same, and the conclusion that the appellant's claim is frivolous, brought malafide, vexatious. The end of quotation. See also the case of Olatunji and Wahid, decided in 2010, citation of which is set out. The provisions of the Electoral Act cannot subvert the clear provisions of Section 131, 137, and 138 1D of the Constitution of Nigeria as amended. Any allegation of giving false information in an affidavit submitted to INEC must be false information of a fundamental that breaches any of the provisions of Section 131, 137, and 138 1D of the Constitution of the Federal Republic of Nigeria. The petitioners insinuated that the officer card is not a qualification or certificate under the Constitution or the Electoral Act. The Oxford Advanced Learners Dictionary of International Students Edition, 7th edition, described cadet as a young person who is training to become an officer in the police or the armed forces. There is evidence on record by RW2 and RW3, 4, and 5 that the second respondent has secondary school education at Katsina Provincial Secondary School, now Government College Katsina, from where he proceeded to Nigerian Military School, Kaduna, from Form 6 in 1962, along with RW1. In effect, the second respondent went through education in the military after his secondary school education. The military training is though higher than secondary school certificate education. The petitioners in paragraph 3.43 in the address, 3.43 in the address, in response to INEC final address, submitted that the second respondent gave false information, which he claimed in his affidavit deposed to on the 24th of November 2014, and submitted to the first respondent via Form CF001 on the 18th of October 2018, when he said all his academic qualification documents as filed by him in the presidential form were with the Secretary Military Board as at the time he made the affidavit. The petitioners also said that they have the Secretary to the Army Board, both in electronic and print media, and also relied on exhibit P80 and P24 to show that the Army emphatically denied the claim, and as such, the onus of proof has shifted to the second respondent to disprove the claim. The fact remains that the second respondent did not call the Director of Army Public Relations, Brigadier General Olajide Olaleye, who pleaded in paragraph 396 of the petition as having debunked the assertion of the second respondent in the affidavit sworn to on the 24th of November 2014. The said paragraph 396 constitutes the fountain and pivot of the petitioner's allegation, and they have the duty to show that the affidavit contained false information of a fundamental nature in aid of his qualification for the election. What the petitioners did through the council was to tender documents from the bar with no one to confirm the authenticity of the report contained in exhibit P80 and P24, and with no witness to cross-examine on it, thereby rendering these exhibits of no probative value, as the court cannot rely on them at the fountain and found in favor of the petitioners. The consistent holding of the Apex Court is that such documents must be tendered through their makers, or where tendered from the bar, the maker or a witness with knowledge of the exhibits must be evidence on them. More so, the petitioners made allegations of crime the cornerstone of issues 1 and 2 in this petition. In the case of Ikpeazu and Oti, 2016, citation of which we set out, Galadima again once said, "It is set in law that a party who did not make a document is not competent to give any evidence on it." This is the situation where PW19 did not make exhibit PWC2. She cannot competently tender it. The maker must be called to testify to credibility and veracity. See also the case of Wike, Yesem, and Peterside, the case of Emmanuel and Umana. But that is not the end of the matter. The matter goes further. And even if exhibits 24 and 80 are admissible exhibits which can be used in this petition, PW can be used, can be accorded probative value and weight. The newspaper in exhibit P22, P24, and in particular, the statement or refutation by Brigadier General Olajide Olale on the 21st of January 2015 does not at all support the position of the petitioners that the second respondent has no certificate or that he was not educated up to secondary school certificate level, as the exhibit is point blank on this issue. The exhibit P2024 point blanks confirms that the second respondent obtained a WAS certificate, otherwise known as West African School Certificate, and that he attended the schools listed in exhibit P1. I will reproduce in full the statement of the Army made under the title "Army Speaks on Buhari Certificates" by one Kingsley Omonobi. The whole report, the complete report, reads, and I quote, "Abuja, as controversy continues to trail the academic qualifications of the presidential candidate of All Progressive Congress, APC, Major General Muhammadu Buhari, the Army yesterday said it was not in possession of Buhari's credential. The APC presidential candidate, Major General Buhari, had averred in an affidavit he deposed before an Abuja High Court that all his certificates were with the Secretary Military Board while submitting his Form 199A to the independent, is from CF001 to the Independent National Electoral Commission, INEC. But the Army yesterday denied being in possession of the APC's candidate's original certificate or the certified true copies. The outgoing Director of Army Public Relations, Brigadier General Olajide Laliye, who addressed newsmen in Abuja, said, and he quotes, "The Nigerian Army does not have the original copy of his, Buhari in bracket, West African Certificate Council, WAEC result, or a certified true copy," end of quote. The report continues, but the APC, in a swift reaction, has warned that those who are bent on destroying Buhari on the basis of his certificates may end up destroying the country's military. The Army spokesman, who told newsmen that the Army had, and which he displayed, were information contained in the forms Buhari filed at the point of his entry into the military and some letters of recommendation by a principal of the Provincial Secondary School, Katsina. For the record, Olajide said, records available indicate that Major General Muhammadu Buhari applied to join the military as a Form 6 student of the Provincial Secondary School, Katsina, on October 18, 1961. His application was duly endorsed by the principal of the school, who wrote a report on him and recommended him as suitable for military commission. The report, which was shown to newsmen, read, and there's a quotation in quote, "I recommend Muhammadu Buhari fit for military commission," end of quote. On Buhari's result, The principal also wrote, and I quote again, quote unquote, I considered that he would pass math, English, and 3 other subjects, end of quote. Laleye said the briefing was necessitated by the deluge of requests from civil society groups and the media, among others, over General Buhari's ineligibility for any political office. He continued, he said, it is a practice in the Nigerian army that before candidates are shortlisted for commissioning into the officer's cadre of the service, the selection board verifies the original copies of credentials that are presented. However, there is no available record to show that this process was followed in the 1960s. Nevertheless, indicated that the former head of state obtained the West African School Certificate, WASC, in 1961 with credit in relevant subjects: English language, geography, history, health science, Hausa, and a pass in English literature. Laleye continued, neither the original copy, certified true copy, CTC, no statement of result of Major General Muhammadu Buhari's WASC result is in his personal file. What I have said here is what is contained in his service record personal file. We have not added or subtracted anything. Earlier, Brigadier General Laleye has said, let me state clearly that the Nigerian Army holds the retired senior officer in very high esteem and respect, and will not be a party to any controversy surrounding his eligibility for any political office. Suffice it to state that Major General Buhari rose steadily to the enviable rank of Major General before becoming the head of state of our dear country in December 1983, end of quote. This statement apparently, clearly, unequivocally confirms that the second respondent actually obtained West African School Certificate and passed credit in 5 subjects in 1961 in English language, geography, history, health science, Hausa, and also a pass in English literature. The statement confirmed the truism and authenticity of exhibits R19, R20, 21, R22, and R23 tendered by the second respondent through witnesses RW3, RW4, and RW5. What Brigadier General Olajide Laleye said is that the original copy or the CTC or a copy is not in his personal file. This does not exclude the inference that the Army may have the certificate, having regard to the fact he stated, which I again repeat. Nevertheless, the entry made on the Nigerian Army Form 199A at the point of documentation after commissioning of an officer indicated that the former head of state obtained the West African School Certificate, WASC, in 1961 with credit in relevant subjects: English, language, geography, history, health science, Hausa, and a pass in English literature, end of quote. Curiosity and common sense will ask the question, if indeed the second respondent did not present his certificate to the Army when he was commissioned as an officer, where did the Army get the record in the Form 199A in his record that he had presented, that in Form 199A, which presented records of credit obtained by the second respondent in the WASC examination in 1961? The plausible and only reasonable inference is that the second respondent presented his certificate, WASC certificate, upon joining the Army, from which the Army extracted the information in the Form 199A to show that the second respondent indeed has secured education up to school certificate level and in fact possessed the WASP certificate in 1961. Section 167 of the Evidence Act 2011 says, the court may presume the existence of any fact which it deems likely to have happened, regard being had to common cause of natural events, human conduct, and public or private witness in their relationship to the facts of the particular case. It will be incredible and even repugnant to common sense and justice to hold on the face of the evidence produced by the petitioners themselves in Exhibit B24 that the second respondent does not possess qualification to contest the office of the President of the Federal Republic of Nigeria as prescribed by Section 131 and defined in Section 318 of the Constitution, or that he has submitted an affidavit to the first respondent containing false information, fundamental in nature or in aid of his qualification. If the Army admits and confesses in the above statement that it has a record which indicates that the second respondent has obtained a WASP certificate in 1961 and even stated the grades he scored in particular subjects, where then lies the falsity of the information deposed to and submitted to first respondent in support of his qualification for the contest, for the election of 23rd February 2019. The petitioners also tendered the CV of the second respondent, showing his educational background, military service, public service, becoming ultimately the head of state and Commander-in-Chief of Nigeria, Commander-in-Chief of the Armed Forces of Nigeria from December 1983 to 85. All of this were confirmed by Brigadier General Olajide Olaleye, who said the second respondent rose steadily in his career to become the head of state of Nigeria. In my view, the CV contains impressive credentials to enable the second respondent contest and hold the office of the President of the Federal Republic of Nigeria, even if it could be said that he has only a primary school certificate, which is not the case here. The second respondent has more than secondary school certificates, having attended courses, evidence of which have been attached to his Form CF001. There is no doubt that the second respondent is not only qualified, but is also eminently qualified to contest the February 23rd presidential election from the evidence presented by the petitioners themselves, as stated out above. The petitioners cannot run away from the facts that are favorable to the second respondent, particularly in exhibits P1 and P24 tendered by them. The fact that the second respondent did not attach his certificates to the CV or to Form CF001 cannot lead to the conclusion that he did not obtain the certificates or that he is not educated up to certificate level or its equivalent as required by the Constitution. Since the documents in Exhibit 24 and 131 were tendered to advance the petitioner's case, this court is entitled to utilize them and validate them and in an advantage position to draw the inference and reasonable conclusion which can be found in such exhibits. A close scrutiny or a perusal of the petitioner's averment in Section 388 to 405 discloses that the case of the petitioners is that the second respondent specifically accuses the second respondent of submitting the form CF001, wherein he filed in paragraph C, column 2, page 3, under secondary school wrote WASC, thereby falsely claiming the qualification which he submitted to INEC, whereas there was no qualification known as INEC as WASC at then. That is the petitioner's case. However, by their own evidence and by their own case, they have shown that the second respondent has obtained the said qualification and that WASC was in existence at the time the petitioner joined the army and submitted his credential to them for enlistment. The second aspect is that the petitioner swore to an affidavit containing false information. Paragraphs 397 and 404 pleaded that the school the second respondent claimed to have attended were not at the material time existent. However, there is no pleading in the petition to the effect that the second respondent's failure to attach his certificate to Form CF001 amounts to lack of qualification to contest the election. In other words, the issue of failure to attach certificate has been overflogged throughout the length and breadth of the petitioner's address
Yeah, we are experiencing a serious network jam, and likewise, every other station is facing the same problem. I believe strongly that something fishy is out there happening, and those responsible actually want to keep Nigerians and the world at large who are watching in the dark. But let's keep our fingers crossed and see what happens. Stay tuned, stay connected, don't go away, stay tuned with us, okay? As we continue to make efforts to bring it back live to you.
Same person. Land Senior Counsel relied on the case of ADR Fayoshi, citation of which is set out. He also relied on the evidence of RW5, who gave explanation on the names and stated they are the same. He drew an analogy from the name of lead counsel for the petitioners, whose names are Dr. Livinus Ifeanyi Uzoku Ezean, signing off processes as Dr. Livy Uzoku Ezean. The variation in name of the second respondent on exhibit R19 and 21 is non sequitur, since both of them refer to and were issued in respect of the same person who bears the names set out therein, whether Mohammed with an O, or Mohammed with a U, or Muhammadu. The names refer to one and the same person in respect of who the experts were issued, or Muhammadu. Particularly, the names, since the name one and the same person in respect of who the experts were issued. Particularly, since the name Buhari on the exhibit indisputably refers to and belongs to the second respondent and no other person. After all, a name is defined at page 1048 of the 8th edition of the Black Law Dictionary to mean, I quote, a word or phrase identifying or designating a person or thing and distinguishing that person or other thing from others. From the totality of the evidence before the court, the names Mohammed Buhari with the U, Mohammed Buhari with an O, contained in exhibit R19 and 21, all refer to, identify, and belong to the second respondent in respect of which they were issued. I am of the view that upon all the pieces of evidence given, both oral and documentary, on the issue of qualification or on the issue of allegation of affidavit, of submission of an affidavit containing false information tendered or proffered in this case against the second respondent, there's no doubt that exhibit R19 and 21 relate to the second respondent. I have no doubt in my mind again that the petitioners have not proved or established that the second respondent does not possess the educational qualification to contest the election of the office of the President of the Federal Republic of Nigeria as prescribed and stipulated under sections 131, 137, and 138, 1A, B, C, Roman 1, 2, 3, and paragraph D of the Constitution of the Federal Republic of Nigeria as amended. I'm also of the firm view that the petitioners have failed to prove or show that the second respondent had submitted to the first respondent an affidavit containing false information of a fundamental nature in aid of his qualification for the election as prescribed by Section 35(1) of the Evidence Act 2011 and settled by the decision of the Apex Court. Before leaving this issue, Learned Senior Counsel for the third respondent had argued what she termed subsidiary issue under the subhead non-qualification of the first respondent in his treatment of the petitioner's issues 1 and 2. All that needs to be said on the issue, all that needs to be said on the subsidiary issue and the arguments thereon go to no issue, since the paragraphs of the third respondent reply to the petition on the first petitioner's qualification to contest the election have been struck out for being incompetent by the ruling of the court on the petitioner's motion of 13th of May 2019 just delivered. As a consequence, after a review, a critical examination and evaluation of all the evidence adduced in this petition, particularly as it relates to issues 1 and 2 of the petitioners, I come to the conclusion that issues 1 and 2 of the petitioners are hereby resolved against them. I now go on to deal with issue 3, which was also canvassed by the Learned Senior Counsel for the parties. And after a consideration of all the submissions on issue 3, I resolved it as follows. Issue 3 deals with ground 15A of the petitioner's petition. And once again, it raised the petitioner state that the grounds upon which this petition is based are as follows. A, the second respondent was not duly elected by majority of lawful votes cast at the election, end of quote. The ground is predicated on section 138(1)(c) of the Electoral Act as amended, which provides for it as a ground for presentation of a petition. The law is that where an election conducted by the National Electoral Commission, including the election in question, a return is made and a candidate is declared as elected, as in this case, then section 68(c) of the Electoral Act, as amended in 2010 as amended, makes the declaration and the return made by the designated electoral body final, subject only to review by the court or tribunal, as and by way of an election petition, as in the present petition. Section 147, 148, 168, and 167, 168(1) of the Evidence Act 2019 presume the result of the presidential election declared by the first respondent on the 27th of February 2019 as correct, authentic, and true until proof otherwise. Because it is a rebuttable presumption, the burden is on the petitioner who claim that the results are not true, they are not correct or authentic. This position of the law has been considered in many cases, a legion of them. And I just refer to the locus classicus, Omoborio and Ajasi, the teaching of which is set out, where Bello JSC then, and later CJN, and also of blessed memory, stated, now, as I stated in Wobodo and Ono, Supra, there is in law a rebuttable presumption that the election result of any election declared by a returning officer is correct and authentic by virtue of section 115, 148(c), and 149(1) of the Evidence Act, and the burden is on the person who denies the correctness and authenticity of the return to rebut the presumption. Where such denial is, again, polling booth at the base of the pyramid, which forms the electoral process under the provisions of the Electoral Act 1982. The booth are the roots which nourish the whole electoral process. Where a petitioner challenges the correctness of the return of an election declared by the returning officer, then except in arithmetic errors in collation, the petitioner must lead evidence which would directly or indirectly establish the votes scored by him and his opponent at the polling booth. Similarly, in Buhari and INEC, decided in 2008, citation of which is also set out, Nikitobi, of blessed memory, has said this, and I quote him: election results are presumed by law to be correct until the contrary is proved. It is, however, a rebuttable presumption. In other words, there is a rebuttable presumption that the result of any election declared by a returning officer is correct and authentic, and the burden is on the person who denies the correctness and authenticity of the return to rebut the presumption. See Omoborio and Ajasi, 1984, 1 SCNR 104, Jalingo and Nyame, 1992, 3 NWLR, part 231 at page 538. Finebone and Brown, 1999, 4 NWLR, part 600 at page 613. Hashidu and Goji, 2003, 15 NWLR, part 843, 352, and Buhari and Obasanjo, 2005, 13 NWLR, part 941 at page 1, end of quote. The petitioners pleaded in paragraph 16, 17, and 18 of their petition as follows, and I set them out. And in order to prove the pleadings and the assertions above, the petitioners are by law under the legal obligation to call oral or documentary evidence through witnesses who are eyewitnesses, who can give cogent and direct evidence and demonstrate before the court that there is any misapplication of votes scored by the parties at the said election. In Atiku, Raja Abubakar Atiku GCON and Umaru Musa Radua decided in 2008, which I have referred to in one of the rulings. Nikitobi again, of blessed memory, has said that a petitioner who contests the legality or lawfulness of votes cast at an election and the subsequent result must tender in evidence all the necessary documents by way of forms and other documents used at the election. He should not stop there. He must call witnesses to testify to the illegality or unlawfulness. Substantially, he must call witnesses to testify that the illegality or unlawfulness substantially affected the result of the election. The documents are among those in which the results of the votes are recorded. The witnesses are those who saw it all on the day of election, not those who picked the evidence from eyewitnesses. No, there must be eyewitnesses too. Both forms and witnesses are vital for contesting the legality or lawfulness of votes and the subsequent result of an election. One cannot be a substitute for the other. It is not enough for the petitioner to tender only documents. It is incumbent on him to lead evidence in respect of the wrongdoings or irregularities, both in the conduct of the election and recording of the votes, wrongdoings and irregularities which affected substantially the result of the election, end of quote. I also made reference to some other cases on this position of the law. And the petitioner, being conscious of the onus of proof heavily placed on them by the law, are pleaded in paragraph 19 of the petition that the petitioners shall lead oral and documentary evidence at the trial to show that the results of the election as announced by the first respondent, and especially the votes credited to the second respondent, do not represent the lawful votes cast. Lawful votes were deducted from the first petitioner's scores by the first respondent in order to return the second respondent, end of quote. The petitioners have tendered from the bar from EC8As, EC8Bs, EC8Cs, EC8E, and other electoral forms or documents, particularly in respect of 13 states, including FCT Abuja, which they call the focal states. They also call, like I said before, 62 witnesses to prove the petition. The order in which the said witness testified and the states and the areas of their testimony have well been captured in the addresses of the parties. I will just reproduce some of them, and I did. The main contention or issue under this issue 3 is that the petitioners, the first respondent, has stoutly denied the existence of a server referred to and pleaded by the petitioners in their petition. The first respondent also vehemently contended that the result of the presidential election was never transmitted electronically via the smart card readers into any server belonging to INEC, and that there's no provision in the Electoral Act 2010 as amended that prescribes transmission of election results from the polling booths, polling units, polling voting points, ward level, LGA level, state, or national level. The same position was also taken by the second and third respondent. However, the Lions Senior Counsel for the petitioners insisted that by the amendment of the Electoral Act in 2015, the Act number 15, which came into effect on the 26th of March 2015, Section 9 thereof amended Section 52 of the Principal Act by inserting the following new section. That's Section 2, which provides thus: voting at an election under this Act shall be in accordance with the procedure determined by the Independent National Electoral Commission, end of quote. The United States said, to the United States for the petitioners, INEC was empowered by this provision to transmit result of election from polling units via smart card readers direct to INEC server by presiding officers or assistant presiding officers. He also submitted that it was as a result of the amendment that INEC made or issued the Manual on Election Technologies, Use, Troubleshooting and Maintenance 2019, which is put in evidence as XBP 33, Regulations and Guidelines for Conduct of Elections, XBP 27, and 3, Manual for Election Official 2019, which was put in evidence as XBP 28. Learned Senior Counsel for the petitioners strongly submitted that the combination of the above exhibits, P27, P28, and P33, constitute the authority and power of INEC under Section 52(2) of the Electoral Act as amended to transmit result of the presidential election from the polling units electronically into INEC server, and that it was the result uploaded into that server through the process he mentioned that gave the first petitioner an edge over the second respondent, relying on the pieces of evidence by PW3, PW4, PW16, PW17, PW36, PW59, and PW60. The issue here is, can it really be said that Section 52(2) of the Electoral Act as amended actually empowered or authorized INEC to electronically transmit the result of the election from all the polling booths across the nation via a smart card reader. The law is settled that if the words of the statute are unambiguous, they must be followed and interpreted in such a manner that would best bring out the manifest intention of the lawmaker. The bottom line is that it is the duty of the court to interpret provisions of a statute in order to ascertain the intention of the legislator and give effect to it. If there is any lacuna or imperfection in the law or statute, it is not the function of the court has no power to amend the law. It is in the domain of the legislature. And I refer to some cases on this. I have read the entire provisions of Section 52 of the Electoral Act as amended, and which I also set out. And I say that in the exercise of the power vested in it by the provision in subsection 2 above, the first respondent, INEC, made and issued Exhibit P27, which is regulation and guidelines for the conduct of elections, and Exhibit P28, the Manual for Election Officials 2019, for the purpose of the procedure to be adopted and used for the conduct of the 2019 elections. In paragraph 8A of Exhibit P27, dealing with accreditation and voting procedure at election, it is provided as follows, and I quote, voting shall be in accordance with the continuous accreditation and voting system, CAVS, procedures as specified in these regulations and guidelines.